All right, folks, welcome back to House Government Operations and Military Affairs. 1 p.m. on February 13th. We are doing some more introductions today. We have folks from the Ethics Commission here. We have Larry Novins, the former executive director, and we're also joined in the gallery by the current executive director of the Vermont State Ethics Commission, Christine Sivert. And this is just sort of an extension of what we were just doing with the CJC this morning on just sort of, I think we almost might get the tail end of the introductions to the primary entities that we work with the most. So we still are waiting for a few people to come back from lunch. Apologize for seats. But Mr. Nevins, we'll just do a quick round the horn with introductions here for you. Representative Matt Byron, Addison 3, Northwest County. Chair of the committee.
Representative Lisa Hago from Franklin 5 on the northwestern border with Canada, Vice Chair.
Lucy Boyden, Harrison, Cambridge and Waterville, Memorial 3.
Michael Morgan, sorry. Sorry. I was waiting, I think I was waiting on that. Michael Morgan, Grand Isle, Chittenden, Alberg, Pilemont, North Hero, Grand Isle, South Hero, and West Milton, if you can keep track of all that. Thank you.
Over Burlington. Falcon, Windsor 2, Cavendish, Weathersfield, and Baltimore.
Kate Nugent, part of self-resident.
I'm Shay Waters Evans from Charlotte and Heinsberg.
Thank you for joining us.
Thank you.
Yeah.
Thank you for the opportunity to be back. I was just saying it was almost 5 years ago that I last appeared in front of this committee. It was March 11th, 2020, the day before everything shut down.
Oh, I was like, oh my God, the 13th.
And it wasn't my fault.
Yeah, no, totally. Friday the 13th.
Yeah.
Mark, yeah.
Pretty amazing. So it's good to be back. Thank you.
Good to see you. It's a brand new world here.
Much better this time around.
Uh-huh.
So H1 is the bill that I believe you're speaking about. And I was asked to look at it, and I have some thoughts on the amendment. The proposed amendment would take out something that's in the current bill that goes into effect in September. And that is in section 1223, there's a section that says whenever the Ethics Commission receives a complaint about a member of the legislature, they forward it to either the House or the Senate Ethics Panel. And then after that referral is made, the panel has 60 days to consult with the Ethics Commission. It's a mandatory, shall consult with the Ethics Commission. And I saw the introduction, introductory testimony that I think you heard back in January about this bill. And there were a couple of things about that came up that I'd like to address them. As I understood the concerns about that change, about the consultation and the rationale for trying to get rid of the consultation, were two. One was that it imposed a time delay on the process for the ethics panel, that 60 days might somehow hold them back or slow down their work. And I believe that's just inconsistent with the language of the bill. The bill itself says within 60 days. So if I'll say you, just to make it easier, instead of talking about the House and the Senate, I'll just say you, referring to the House. If the House Ethics Panel receives a complaint and they want to hear from the Ethics Commission on how the Ethics Commission views the facts that were sent over with the ethics code, they could do that on day 2 without any delay at all in the process. You have 60 days to allow yourselves or the ethics panel to look into the case more, to see if any more discovery or information is needed before moving forward. And whenever the ethics panel feels it has enough information to ask, how does this all stack up against the state ethics code, then they can do that, but it has to happen within 60 days. And I believe the rationale for the 60 days is to make sure things don't languish, just to make sure that things actually move. So I don't see the 60 days as a problem, as an issue. The larger issue really is the question about whether or not this requirement to seek consultation with the Ethics Commission is somehow a violation of separation of powers. And I believe it is not, for several reasons. I'll go through them. One is when, and again, I'll say you, meaning the House, ask for a consultation with the Ethics Commission. What you will receive back is their view of the case and the evidence that's been acquired and amassed, whether it's evidence they had and sent over to you or evidence you acquired on your own. In the course of that consultation, you are not required in any way to share, you again, meaning the House Ethics Panel, you're not required to share with the Ethics Commission any information that you acquired on your own. You may if you wish, but you don't have to. And when you consult with them, you say, here's what we have, here are the facts we have. How does this stack up with the ethics code? And I guess I should have started with this, but the ethics code is basically a bottom line standard of conduct for public servants in state government. It applies to everybody. It applies to the governor. It applies to the judicial branch. It applies to the legislative branch. So whether you are an attorney working for the judiciary or working in this branch or working for the executive, it applies to you. If you're a person who orders stationery or a computer IT person, it's the same code that applies to everybody. So when the ethics panel receives a complaint and they are now at the point where they need to consult with the ethics commission, that it says the communication must be in writing. They write to the ethics commission and say, we'd like your opinion on how what we have or how what you've given us stacks up against the ethics code. And then the ethics commission will promptly respond and say, this is our view based on the information we have of what occurred and our view of the code and what the code requires or addresses and doesn't address. The reason for including the ethics commission is because of all people in state government, they are the ones with the unique expertise in the code and how it is applied to people. They've already been in the business of issuing ethics advisory opinions, so they have a good sense of how the code is supposed to work. And they really have the expertise. And what the requirement for consultation does is say, hey, House or Senate ethics panel, before we make a decision on whether the state ethics code applies to this conduct, talk to the people who have the expertise, talk to the people who know it the best, and hear what they have to say. Now, when you've consulted with the ethics commission, then they respond and they say, here's how we look at the case. Here's how the facts stack up. Here's what the code requires. And here's where there may or may not be a violation. You, meaning the ethics panels, can do whatever you want with it. Your process is completely confidential. You can take what they say and say, yep, we agree, and affirm it and make a finding based on that. You can ignore it completely. What the requirement does is just say, listen to what they have, listen to people with the expertise, and then do what you would do normally. Make your own decision. Somehow, we hope, better educated in what the state code means. But ultimately, the decision is yours. And in the beginning, when we talk about separation of powers, there are powers that the legislature has that are uniquely yours. No one else has these powers. You have the power to decide, the qualifications of your members. It's right in the Constitution. And that has always been understood to say qualifications, meaning to take their seat or to hold their seat. And that is presumably the rationale that allows the House to take, and the Senate has a similar provision, to take action against any of their members who transgress the norms as they're known to each body. So getting a report from the Ethics Commission that says, here's our view of the case, doesn't impinge on that core function. The House retains its ability to make decisions about qualifications of its members. It retains its ability to do its own independent fact-finding and decision-making, and ultimately to decide the case before it. They can decide if the person has violated the state code of ethics. They can decide if the person has violated your own House rules or Senate rules, in the case of the Senate, without any really interference on the part of the Ethics Commission at all. All they do is provide expertise that you can accept or decline. That's it, nothing more than that. So in that context, I don't see it as a violation of separation of powers already in our law. I mean, the Constitution is very clear that each branch of government has its own unique core functions that only they can do. But there's lots of overlap between branches of government. You know, that people have to file disclosures. You have to go to the Secretary of State to get your charter. I forget exactly what it's called before you can take office. And if somebody violates a criminal provision, the fact that they're a judge or a legislator is not a bar from the executive branch going against that person. So Kristen reminded me of a memo that I wrote a couple of years, well, 5 years ago about separation of powers. And if you wanted, I'm sure that they could provide it to you. In that memo, I talked about whether applying the code, because at that point it was still a dream, to the judicial branch violated separation of powers. And our conclusion was it did not. And in enacting the code of ethics and applying it to all branches of government, the legislature agreed and recognized that no, this basic bottom line code of conduct for public servants applies to all public servants, no matter what branch of government you occupy or work in. So just to summarize, there was argument made in the first hearing about somehow this consultation requirement impinging on your ability and to decide your own fate or the fate of your members. What you do with the consultation you receive is confidential. What you do with it is confidential. What you don't do with it, if you choose not to do anything with it, is confidential. The information you receive in the consultation does not in any way impede your ability to conduct your own investigation. You have the power under the House rules to subpoena witnesses and compel the attendance of witnesses. That remains unfettered. The information you receive from the Ethics Commission in no way dictates how much weight you need to give it or any other information that you get. And the Commission's role in providing consultation is only to let you know with its expertise how it views conduct. And like advice that you may get from anybody else, you can take it or leave it, because the bottom line, the ultimate decision on the qualifications of your members is yours and yours only. And the consultation doesn't say, the only thing the consultation will say is, we believe this is a violation. What you do with it, whether you excuse it or sanction it in some way, is entirely up to you and remains up to you. So the view of basically what the commission is doing.
We have a question here from the representative.
Oh, sure. I'm sorry.
Yeah, no worries, no worries.
So just to summarize, so you said the way the law stands right now, it's not requiring the legislature to do anything. It's not.
It requires the legislature to ask for consultation.
But other than that, I'm saying with that
Nothing.
information, there's nothing else that happens after that that we're compelled to do.
No.
So then my follow-up question is, so what would H1, in your opinion, do that would be harmful or detrimental, or why would it be? What would be the reasons to oppose passing it through?
A couple. One is what H1 is written says to Vermonters is that the legislature, in making decisions, not regarding your own rules, but regarding the state code of ethics, will speak to the people who have the best expertise with the state code of ethics. And this is sort of getting to my last point. But the optics of this, I think, are terrible. You know, everybody knows what's going on nationally in terms of ethics in government. And I think we're all very aware of what happened in the election in 2024. And I think the public is skeptical of what, I say we, because I was in state government for so long, what we do, what you do, and suspicious of what we're doing and what you're doing. And I think to say that we're not interested in hearing from the people who have the best expertise in this particular area before we make a decision is saying to the public, we're gonna do whatever the heck we want. And we don't care what anybody else thinks. And I think it just reinforces the skepticism and the suspicion that a lot of people have. I wish that wasn't the case, but I think it is. I mean, to me, it's sort of a win-win. It allows the Senate and the House, when they make a decision, whatever it is, to say, we heard from the Ethics Commission, we got their input, we were thankful for it, we reviewed this case. And after our own investigation, after hearing from them, we conclude that this was not a violation or it was a minor thing that can be excused. I think it gives the legislature a little bit of cover and says to them, says to the public that you were able to make a well-informed decision about a complicated ethics matter that is really the bailiwick of the Ethics Commission, and they're the people with the best information. And all you did was open your ear up and listen to what they have to say and make your own decision. So that's the long and the short. I could drone on, but I don't think anybody wants it. Yeah.
Representative Hooper.
And refresh, something I probably missed. Is that consultation public knowledge?
No.
Confidential,
Absolutely not.
discoverable,
Nope,
favorite information?
nope,
Okay.
no. The referral itself, when the Ethics Commission gets a complaint, it is confidential and they can't disclose it to anybody. When they refer it to you, if it involves or somebody from the legislature, that referral is confidential. And then your own rules take place and whatever you do is confidential. And the consultation that you have back with the Ethics Commission saying, what do you think of this, is confidential. There's no way that's getting out. Can I sum up?
Please.
I think if it ain't broke,
Sorry,
don't
that's
fix it. Whoops. My sense is if it's not broken, don't fix it. I don't know if anybody has any questions, so I'm happy to answer.
Any other hands? All right,
Thank you.
thank you.
Thank you.
Yeah. Feel free to stick around in case there is any other
Yeah,
questions
here.
that pop up that are relevant to you and your experience. All right. Director Sybrant, good to see you.
You too. And yeah, and I just add a couple of things to what Larry said. I think I heard Representative Lalonde's testimony last time. And one point that I want to make clear that I thought was already clear was that when we're talking about the consultation requirement, that does not apply to fact patterns that involve core legislative functions. Those are already exempt under the state code of ethics. So things like committee assignments or whether there's conflict in voting, that's already exempt from the entire consultation process. And that is because it is exempt in the state code of ethics. So I just want to make that clear. And also the reason for this request. So this is meant to promote engagement with the different branches of government. We have different levels of engagement with the different branches and different entities that are involved in investigating complaints. And so one of the main purposes of this is to promote engagement and promote a common understanding of the state code of ethics and how it's applied and make sure that it's uniformly applied, regardless of where somebody sits in government. They all have the same understanding of the rules that apply to them and then how they're being applied to them. So those are two important points that I just wanted to make in terms of why this request was made and the fact that when we're talking about constitutional concerns, that is already provided for in the state code of ethics. That was discussed at length when the state code of ethics was passed, what could be covered by the state code of ethics and core legislative functions were exempted at that time. So I know we're running short on time. So what I was going to do is just kind of introduce the Ethics Commission. We have our annual report. I can try and make that brief and then just go over our recommendations. And then I'm sure people have some questions about the municipal ethics portion of the legislation that was passed last year. We now have a couple of months of experience. I can talk about that. But for the new members, I just want to explain what the Ethics Commission does. We are primarily a services organization. So we provide advice and guidance to all state of Vermont public servants. That includes employees as well as elected officials and some categories of volunteers. We now provide advice to some categories of municipal officials. People can request advice related to the statewide municipal code of ethics or the state code of ethics. That can be informal advice. They just call us up. They don't have to say their name. They just say they have something they want to talk about, or they can make a written request for an advisory opinion that is posted on our website. We already have 2 requests this year, both from municipalities, and those are generally for questions that are more complicated or more common, and we think people would benefit from seeing the answer posted. Person identifying information is redacted from those advisory opinions, and people know that they'll be posted before they make that request. The other thing that we do is we receive complaints. When we engage with the public, we primarily engage with them through the complaint process. They'll call us and say, this thing happened to me, is this unethical? We talk about whether it's unethical specifically in the context of the state code of ethics, not general unethical behavior, but would this be a violation of state code of ethics or now the municipal code of ethics? And then talk about whether it would make a valid basis for a complaint moving forward. At this point in time, we refer complaints. In the future, we'll have investigatory powers, but we refer complaints to House or Senate ethics panels, to the Judicial Conduct Board, to DHR, and when it comes to municipalities, we refer it to the relevant municipality that is involved in the complaint. All right, the other thing that we do is training. So as my predecessor, Larry Novins, mentioned, our primary responsibility is to administer state code of ethics and interpret it. And so part of that is to provide training so that we can pass on that knowledge to other people. And so we have an online ethics training for state public servants. And now we also have an online training for municipal officials who are subject to the statewide municipal code of ethics. So we have about 100 people a week taking the municipal code of ethics training online. We would very much like to extend in-person training to both state employees, state public servants, as well as municipalities. But right now we are still operating with a very small staff of 2 people, 2 part-time people, I should clarify. So myself and an administrative assistant, and then we have a consultant, TJ Jones, who I assume will come before the committee at some point in time. But he is the former state ethics prosecutor for Connecticut, and he's also a professor at UConn of ethics and public policy. So most of you have seen him before, but the newer members would not have seen him before. Since the Ethics Commission was established, we've seen an increasing demand for services over time, particularly since the state code of ethics was passed, and now within municipal code of ethics. Municipal questions now make up the majority of the requests that we're getting. So for example, last year we had, I think, 37 requests for guidance for the entire year. Last month we had 20 something, and they were almost all municipal. So we are providing services to municipalities at this point. The subjects that people request information about, it's pretty much the same in the state government as it is in municipal government, and it relates to conflicts of interest, preferential treatment, and occasionally misuse of position, misuse of resources. So I'm trying to make this quick without boring people. So I don't know, maybe I should stop here and see if anyone has any questions about what we do, particularly newer members.
Anyone? No. All right, keep going.
Okay. The other part of the ethics package that was passed last year was an expansion of financial disclosure requirements. So it moves beyond executive officers and certain candidates to include some categories of county officials. I will say we have our office has an online filing disclosure system. The candidates, I think, still go through, a paper form through the Secretary of State's office. We are hoping to work with them to merge into one online filing system. And also there was penalties adopted last year because we had a number of people who were filing late and some not at all the year before. I'll say this year we had a lot of success. We had almost everyone file on time. At this stage, we only have one person who's not filed. I don't know why. We sent out multiple reminders. So this year we in fact may have to actually impose a penalty on someone, but we'll see what happens. But generally speaking, there's almost complete compliance with the financial disclosure law. Okay. So part of our annual report requirement is to give our recommendations on what we can do to strengthen ethics laws more than they are now, and also campaign finance laws. So just going through what we have here in the annual report, I'm not sure if people have had the chance to read it, but First recommendation would be to expand commission membership. And so actually, I think this relates to the constitutional questions that are percolating in H1 when it comes to the Ethics Commission. So one thing I do want to make clear about the Ethics Commission is that we are not an entity of the executive branch. We are set up within the executive branch, but that is solely administratively. This is normal. This is standard in states that have uniform codes of ethics that apply to all three branches of government, to have them set up in the executive branch, but not be of the executive branch. We are independent entity. We do not answer to the governor. We do not answer to anyone else in the executive branch. The commission is the governing body. And so as of last year, the commission has 2 legislative appointees, and we also have an appointee in the judicial branch. So we have those 2 branches of government represented in our, kind of governing body of the commission. We do not have anyone in the executive branch represented there. We do think that needs to change in the future. We do think it is fair, since we are an entity that represents all 3 branches of government, to have somebody in the executive branch have an appointment, and the logical person would be the governor. And that can either be accomplished by adding additional slots to the Ethics Commission or converting one of the slots that is there now. So just going to, apologies. Okay, so our other recommendation is to begin to consider a method of enforcement for the municipal code of ethics. So that was something that was purposely, I think, not discussed last year. We did not include it in our research. We drafted a report last year to talk about municipal ethics, our proposal for a municipal ethics framework for the state of Vermont. We did not address enforcement because we felt like the time was not right for that. And so where we landed was that municipalities would be enforcing the municipal code of ethics. We've included in our report our recommendations for options to consider in the future. I think there was a recognition that, for people who felt like they weren't having their complaints heard in an impartial manner, having the investigations handled solely by the municipalities was something that was not going to satisfy them. So we have given 3 different options at the end of the report. One is to keep municipalities as the investigating authority. The other is to set up, regional boards where you would have, maybe northern and southern Vermont divided into different quadrants, and then somebody could file their complaint with a regional board who would then investigate the complaint, so you'd maintain local knowledge. But then at the same time, you would have that independence that people file complaints for. Then you have the option of setting something at the state level, so either having the Ethics Commission or a new state body hear municipal complaints. Our recommendation is that investigations stay with municipalities, but that potentially the Ethics Commission would hear appeals to hopefully create that balance between maintaining local knowledge, but also having some kind of independent authority reviewing complaints when there is a need to do so. Okay. Our next recommendation is expanding funding and staffing for the commission. So this year we requested 2 staff members. We requested them last year. We did not get them. I think that was partially our fault because we did not make the request in our initial budget request. We didn't know what was going to happen with legislation and whether we would actually need this additional staff, but we have requested 1 legal counsel and 1 staff attorney position. The staff attorney position would be envisioned as being somebody who has knowledge of, who's worked with municipalities before and also has some experience or is willing to do training. The legal counsel position is somebody who's going to handle investigations. The development of mediation options for ethics complaints. So an idea that we've been thinking about for some time, we actually applied for federal earmark funds last year, is to develop a mediation option that people could request from the Ethics Commission. So what we'd envision is having a panel of mediators who don't work directly for the Ethics Commission, but they're available to us. And so if a municipality or somebody working in state government said, before we file a complaint, but what we really think would be useful here is mediation, we could assign the mediator, we would pay the mediator's bill, but then they would be, directly responsible for engaging with the municipality or with the parties themselves, and then just submit like a basic report back. So we're working on how to do that in the most economically feasible manner that we can do. I think everyone has kind of agreed that it's a good idea, but how we implement it is the question. We did not get federal earmark funds because we did not fit into one of the buckets that they were looking for. You have to fit into the very specific buckets. We did not fit. Okay. So improvements and corrections to the bill last year. So when we're talking about municipal ethics, we found that there's some confusion about the definition of municipality. So we have, conservation districts, we have utility districts who all assume that the new code of ethics applies to them. We've had a number of people who've submitted the names of ethics liaisons for those districts. We've had a number of people call us hoping that they were covered by, the statewide municipal code of ethics. but I have to tell them that no, not at this point in time. So we do think that, I'm not saying this year, but at some point in time, taking a look at how we define municipality and whether it should be expanded. I'd say we're having the same issue when it comes to who is subject to the statewide municipal code of ethics and the training requirements. So the way it is now is that there are certain categories of municipal officials who are required to take the ethics training, and then a larger pool of municipal officials who are subject to the statewide code of ethics. So I don't think that the bill came out of this committee that way, but it kind of got watered down over time. So we do have a number of people confused as to whether, if they're subject to the code of ethics, do they have to take the training? Some municipalities are addressing this by just making everyone take the training. That's become clear. Other ones are, more confused. We've heard feedback that they think it should just, the municipal code should just apply to everyone and make it easy. I do think that's something that needs to be considered in the future. Okay. Let's see, disclosures. Okay, the one thing that we felt was really, really important last year, and this got taken out at the very, very end of discussion about the bill, was retaliation protections. So we wanted to have retaliation protections for people who file complaints, members of the public, as well as municipal officials. Members of the public were taken out, and then eventually municipal officials were also taken out. I've had so many people call me and describe situations where they're afraid to file a complaint. Municipal officials and members of the public alike express fears about retaliation, and now we don't have anything to offer them. The retaliation protections were in there in part because there is no independent authority to hear municipal complaints. So people in the first instance are afraid to file with their municipality. Maybe they're more comfortable going through the ethics commission, but then it'll end up with the municipality. We wanted to at least offer them something to make them more comfortable for raising ethics issues. That was taken out at the end, and that's something that we were very disappointed to see. So we hope that that will be reconsidered in the future.
Representative Waters.
But always have a question. Do you remember the reason, because I cannot, why those were taken out at the end? Like what the reasoning was behind that?
Vermont League of Cities and Towns was very opposed to it, and they thought that there shouldn't be any language that didn't match state language. So what ended up being in there was protections for employees only if they were directed to violate the law, which was very different from what the retaliation protections initially stated, which was anyone who files a written ethics complaint, it has those retaliation protections, and that would include members of the public, and it also include municipal officials. So if you're an appointed official, if you're an employee, and so it was limited to the exact same language that is in this in state law, but it does not really apply here. It's actually very clunky. It doesn't work. It was just copied over, and we explained that the reason why those two things should not be considered to be the same thing is because when you have a complaint in state government, there are multiple pathways to resolve that complaint. That's not the case at the municipal level. So if you have a complaint about somebody, in the Agency of Transportation, you could first, reach out to their supervisor. You can file a complaint that goes to DHR. You can follow an internal AOT process. There's just multiple levels of people who can look at that complaint and help resolve your issue, and that just doesn't exist at the municipal level. So they're two different animals. Okay. And the last recommendation was improvements to candidate disclosures related to lobbying. So every year we kind of look at where Vermont is very behind when we are comparing ourselves to the rest of the country. And one of those is the quality of our lobbying disclosures. We're ranked very low in New England. We're ranked very low nationally. That is something that I presented to Senate Government Operations. There was a couple of people who were kind of excited about drafting a bill potentially this session to address that issue. And I'd be happy to come back and discuss that more and bring our consultant, TJ Jones, who was the one who identified this as an issue that needed to be addressed. So that's my quick overview, I hope, of the annual report. So if there's any questions.
Anyone from the table? No, thank you very much. That was a good footing for the work, some of the work we're gonna continue to do. All right, so next we are shifting over to H1. Some of the folks who are in the room right now, it's kind of a combo pack of brain pans. We will start off with Legislative Council, Mr. O'Grady. Good to see you. We don't get much in here.
How you all liking your new room?
Working out.
Yeah. Pretty
Our elbow
comfortable.
room, we don't have quite the ceiling height as, the old place, but we're making do.
Well, the ceilings are definitely higher than when our offices were in here and I could literally bump my head on the sprinkler system.
You were like there-ish?
I'm on the other side of that wall.
You're on the other side of
My
the wall,
office
okay.
is still there. I'm gonna put up a PowerPoint presentation. Autumn, can you let me share? So I'm gonna first give background as to why there are concerns from the House panel, ethics panel, constitutional and otherwise, and then to review a proposed amendment to H1 from the House ethics panel. And I think resolves all the issues from all sides, but who am I to say? Well, first off, let's start with what the current law is regarding the procedure for accepting and referring complaints at the State Ethics Commission. You'll see there in 1223A1 that the executive director accepts complaints. It doesn't say just complaints related to the state ethics code. It says complaints from any source regarding governmental ethics in any of the 3 branches of state government. So that could include a complaint regarding an ethical issue that is within solely the legislature's authority or solely within the judicial's authority. So that state ethics commission collects that complaint. There's a preliminary review by the executive director, and then going on to the next slide. Again, this is existing law. If the complaint alleges a violation against the legislature, House member complaints referred to the House ethics panel, and a report is requested back from the panel. Same scenario dynamic for a complaint against a senator, similar for a judicial officer and an attorney. So that's right now, there's no required consultation. There's opportunity to request consultation if the panels or the judiciary wanted to, but there's no mandate to do so. So then you go on to last year, 2024 Acts of Resolves number 171. You can't really see that language there, but what the operative language that's really at issue is there's this provision that says if the executive director refers a complaint under subsection B, again, it's any complaint. It's not just one related to the State Ethics Commission or State Ethics Code. The executive director shall signify any likely unethical conduct in any entity receiving a referred complaint, except those in subdivision B5, which are municipal, shall consult with the commission, shall consult. It doesn't say shall request. It says shall consult with the commission. So that's a mandate regarding the application of the state code of ethics to facts presented in the complaint. And the consultation shall be in writing and shall occur within 60 days after an entity receives a referred complaint and prior to the entity making a determination on the complaint, meaning either closing a complaint without further investigation or issuing findings. So first of all, there's a practical issue here with the legislature. 60 days, waiting up to 60 days, you might be out of session. You might be done with the biennium. You might not have time to wait 60 days in order to respond to a complaint. So previous witness said 60 days is an issue. 60 days is an issue for the legislature, just practically. And the panel has to wait up to 60 days before closing a complaint. They have to wait. That's a restraint. So the House has sole authority to judge its members. You'll see that it was referred to earlier. The representative so chosen shall have power to judge of the elections and qualifications of their own members. They may expel members, but not for causes known to their constituents and antecedent to their election. And the Vermont Supreme Court has said that that authority to judge its qualifications is an exclusive constitutional prerogative. It's the sole authority of the legislature to review the qualifications of its members and to determine whether there are any interests which require disqualification from voting on a question. It's the sole authority. That means the authority should not be conditioned on action by others.
And just a reminder to the committee that this is the content that we went over from Bennington 1 elections. And members last year, remember last biennium, the establishment of the special committee on impeachment inquiry. This was also referred to during the process.
So remember, the panel, Senate panel, has to wait up to 60 days. Again, they're restrained in exercising their sole exclusive legislative authority. Prior restraint is almost always unconstitutional. Prior restraint is when government restricts constitutional speech or action before it happens. Prior restraint on speech and publications are the most serious and the least tolerable infringement on First Amendment rights. You have to show a compelling state interest and usually some sort of imminent danger in order to overcome a prior restraint. I don't think you have that situation here. Moreover, a prior restraint on legislative action, you hardly ever see it because it hardly ever done. Because the legislature will hardly ever condition its sole authority on interference from an executive or judicial. But when that happens, it is almost always unconstitutional. Wherever there are other doctrines which apply, one is called the political question doctrine. That's usually about when the judiciary is reviewing actions that are solely within the authority of the legislature. But it also applies when the executive tries to control what the legislature is doing. It's a political question. It should not be the question or the authority of the executive to interfere with the sole authority of the legislature. And the statute says the State Ethics Commission is the executive branch. And it says it is within the executive branch. That is a quote. So it is not the legislature, it is not the judiciary, it is the executive branch. Yes, they might be independent, but it's still the executive branch. And regarding separation of powers, yes, there is gray area. The Vermont Supreme Court has said that the powers of each branch do overlap, and that doesn't necessarily mean that there's a separation of powers violation. The court has said when there's a total usurpation of one branch's authority by another branch, that is a separation of powers. For 60 days, the legislature's authority is potentially totally usurped while it waits for a consultation with the State Ethics Commission. That is not just a gray area. So let's talk about what the House panel is proposing. So for referral for context, again, the executive director accepts complaints, they do the preliminary review, none of that is changing. With regards to legislative and judicial branches, the State Ethics Commission, the director still refers the complaints to the State Senate Ethics Panel, House Ethics Panel. If the State Ethics Commission would like to just only refer those that are only within the authority of the State Ethics Code, I think the House panel and the Senate panel will be fine with that if that's how they would like to clarify that. But that is not actually what the House panel has proposed. It's leaving all of that authority intact. What would change would be in that requirement for consultation. And it is a requirement. It's not a request. It's a requirement. If the executive director refers a complaint, the executive director shall signify any likely unethical conduct described in the complaint. For those complaints referred under subdivision B4, which is for the legislature and for the judicial, The executive director shall specify the application at the time that they refer the complaint. There's no need to wait 60 days, 10 days, 15 days. When the complaint is received, commission can issue its recommendation on application of the State Ethics Commission, State Ethics Code at that time. Now, the commission might say, oh, they might need time to investigate in order to determine whether or not the code applies or how it applies or what their recommendation is. That's fine. Just do it before you recommend or refer to the House panel or the Senate panel. There is no requirement that they have to refer within a certain period the ethics complaints that they receive to the legislature. There's no restriction on when they have to send it. They can do their investigation before they send it, instead of putting a prior restraint on your sole legislative authority. For all other complaints referred under subdivision B, those are like HR complaints, those are complaints of law, breaking the law, that are referred to the Attorney General. They still are going to be handled in the same way as proposed for effectiveness in September, that they will have 60 days on those entities where they're going to have to wait for the commission to provide its recommendation. And then to clarify, any advice the commission provides during the consultation process shall be confidential and non-binding on the entity. I just want to also address a statement that was made that you don't need to fix what ain't broke. Well, this isn't even operating. It doesn't go into effect until September of 2025. And I would recommend, before you put something out there that is broke, that you fix it.
Understood, counsel. Thank you for the recommendation. Questions from the table? Yeah, no, there's a lot of catching you two up on this.
Yeah.
No. Oh, did you have a question?
No, I was just.
Yeah, she was just kind of motioning. Yeah, no, I caught yes, I caught that. Did you have a question? No.
No,
Yeah, no, it's just a lot.
We're all
I'm
just
sorry.
waiting
Yeah,
for
I'm-
each other?
Gotcha.
I'm actually reading
Yes,
rereading this again.
this is us just getting a better understanding, a deeper understanding of what we're kind of wrangling through right now. So if you feel overwhelmed, quite frankly, you should. Representative.
What are some of the most common ethic errors that people do without knowing that it's unethical?
Well, I would say the House Ethics Panel, the most common is a conflict of interest. That's what many of the complaints are about.
Makes sense.
All right, well, thank you, counsel. We're gonna keep going through our list of witnesses. So we appreciate that. And we will certainly refer to you if you have questions within the context of this conversation. Christina, Larry, would you folks like to follow that up, or?
I'll just make two quick comments because I
Then
prefer
please
to
say
like really
the same.
testify about this when I've had more chance to absorb it because I did not see this new version. Sorry. Just two very quick comments that I want to make is, so we're talking about, not being broke, if something isn't broke, don't fix it. There's a reason why this was proposed, right? The reason why this was proposed is because from our perspective, the code of ethics is not being interpreted uniformly in a uniform way and applied in a uniform way. So this is our attempt to educate and make that correction in a way that is, least burdensome to other people. Right now, we don't provide training to legislative branch at all. We do provide training to the entire executive branch. The judicial branch takes our training as well, but there are kind of like black holes in what is going on. And to be honest, we have experienced dozens of complaints at this point. We do get reports back on the results we've had a number of complaints that on their face are a violation of the state code of ethics. Reports that we get back occasionally say, close, no findings of violations. And to us, that is a conflict that we've seen repeatedly, and that's what we're trying to correct through education. When you're talking about the 60-day requirement, the 60-day requirement isn't a 60-day requirement to wait for us to respond. This is to the benefit of the investigating entity. They can start the clock whenever they want to start the clock. No one is going to be waiting 60 days to hear from us, right? Like, we pretty much have a turnaround time within 2 to 3 days. The reason why we had that 60-day window is to give an outside time period as to when the consultation has to happen, so it doesn't drag on too long. But the person who's receiving the complaint can trigger the process whatever they want. And the reason we do this is because we don't investigate complaints that we refer, right? So we're not conducting any external investigations before we refer a complaint on. But the entity that is doing the investigation may want to ask our advice after they've had the opportunity to gather more facts, because it may not always be clear on the face of the complaint whether there's a violation or not. I mean, we wouldn't be referring, if there's not a violation and it's clear on his face, we wouldn't be referring it over, but there's an argument that there could be, right? And so to fill in that picture, you want to have more information. It's up to the investigating authority to collect that information and share it with us if they want, and that is to their benefit, so they can make sure that they're applying the state code of ethics in a way that's actually in line with the state code of ethics. So the 60-day consultation requirement is not a restraint, it's to the benefit of the entity that is doing the investigation. If anybody wants to shorten it, that's fine. But the reason why we have a requirement to consult after we've heard the complaint and we don't put all that information in upfront, number one, it is because we won't always have all the facts necessary to make that recommendation at that very first step. But also the purpose of this is for engagement, right? There's no engagement with us if we just continue referring complaints as we do now. What we are trying to do is establish a conversation so that we can share a common understanding of what constitutes a violation of the state code of ethics. There's a requirement that it is in writing, so that it's in writing and is part of the record and it can be shared with others. So there are multiple reasons why this was written the way it was. And I'll say that it's very surprising to have this come back this year when it was something that was just passed and went through legislative council last year. So none of these concerns were raised then. And this was also discussed, in Senate Government Operations. There was a review for constitutional issues. Somebody from the Judicial Conduct Board testified their flags, what they thought might conceivably, encroach on their power. This was not one of them, but I know that Legislative Council last year went through it with Senate Government Operations, and they only included what they felt like passed constitutional muster. So the separation of powers argument is nothing new, and we'll talk about that, another time. I just wanted to just kind of address those 2 points quickly.
So one of the overarching views of the committee, this by any of these all over past sessions, not just this. If it's unexpected for your specific purview in this room, sorry about that, but it is one of the things that we're doing. It's a broad scope of review for things transpired for several years. So.
Yeah, just so you know, the constitutional issues that are being raised right now, they come up every single year in the context of the Code of Ethics. They're not new arguments. At this point, there's nothing in the state code that related to ethics that has not been reviewed multiple times by constitutional law experts, by legislative council, by legislators, by us. So while it may be a new argument this year on this specific narrow issue, this is something that we hear the same arguments over and over and over again. And every year they get rejected in favor of what has actually been included in ethics legislation. So Larry might have further comments, but
I've got a question.
No, I actually had a question for Legislative Council.
Oh, Legislative Council. Okay, thank you.
What if there is a requirement that they respond within 3 hours? Let's say, would that still be considered a restraint on the?
Who responds?
What if the 60 days were 3 hours? Is that still the same thing at heart? Is it still the same issue?
It's still conditioned on the exercise of the authority of the legislature's panel.
Okay.
So I still think it's not as significant, obviously, but it's still a condition. You have the executive conditioning. And to say that it's an opportunity for the panel to reach out, it's an opportunity after they receive the complaint So it's a condition, it's a limitation on them for up to 60 days. So it says shall consult. It doesn't say they may consult if they want to consult. It says shall consult. That's a mandate. That's a restraint.
Please.
Yeah.
The consultation is initiated by the person who receives the complaint. They could ask for a consultation on day one, the day they get it, or day two. They have 60 days to ask for it. Any delay or any restraint is, well, there is no restraint. The timing is completely up to the entity that receives the complaint to decide when they want to ask for a consultation. So in no way is their ability to decide the case or render an opinion affected by this requirement. All it says is within 60 days, ask the Ethics Commission how the facts jive with the ethics code. And as I said, they could do it on day one or day two, or they can wait 50 or 9 or 60 days if they wish. The requirement is just to make sure that it happens. That's my only response.
Thank you for your opinion.
Yeah, thank you.
Terry, good to see you.
Your new space is lovely.
Isn't it?
Yes.
Yeah.
Very good. I'm Terry Corson, State Court Administrator, and I'm joined remotely by Attorney Merrill Bent, who's the chair of the Judicial Conduct Board, and by Attorney Carolyn Anderson, who's the chair of the Professional Responsibility Board.
Thank you, folks. Can you hear us okay? All right, that's one thumb up. I got 2 thumbs up. Look at us, we're winning. All right, so I guess we'll do this as a group exercise with 2 virtual and 1 here in 3D.
Hybrid, like a hybrid court hearing. We very much appreciate the opportunity to comment, and I apologize for not having a ton of familiarity. There was reference made to testimony, and it was Attorney Merrill Bent who testified last year, but my understanding is that this particular provision that we're here on today regarding the consultation requirement was not present in the bill when Attorney Bent testified. It was something, from what I understand, was added at the very end. So we did not have the opportunity to comment. And
I'm seeing a shaking at the gallery.
No, it was definitely what she testified in Senate Government Operations, and this was in the House version of the bill. It was there from the very beginning.
Meryl, I didn't know if you heard that.
I did. I mean, I don't remember this particularly at what point, but I do know that my testimony included the fact that any oversight over judicial officers is outside of the jurisdiction of the Ethics Commission. That's in my testimony.
Well, in any event, oh, sorry. It was not something specifically that I know I was not aware of it. And when it was brought to our attention in terms of H1, we very much appreciate the opportunity to comment and certainly support the legislators' arguments for similar constitutional reasons. And reference has been made to constitutional arguments been made in the past. We'll continue to make those constitutional arguments because we consider it's critical. Given the mandate in the Vermont Constitution, the Supreme Court shall have administrative control of all the courts of the state and disciplinary authority concerning all judicial officers and attorneys at law in the state. That's part of the Vermont State Constitution. And born out of that, and basically based on centuries of ethical obligations that attorneys and judges alike have been bound by, we have the Vermont Code of Judicial Conduct, and we have the Vermont Rules of Professional Conduct, both of which are the basis of extremely robust disciplinary programs that control both attorney and judge ethical obligations. An attorney has to pass an ethical portion of the bar exam to even be licensed. There are continuing legal education requirements every 2 years, a component of which has to be ethical training. Our position has been that that has then provided the basis for, and the Supreme Court has honored what the Vermont Constitution requires, and that is disciplinary authority. I very much applaud the State Ethics Commission and, for example, where the municipal bodies did not have a code of ethics. I serve on my town's planning commission. I think that's great to have some guidance for for an area where nothing existed before. That's quite a contrast to judge ethical obligations and attorney ethical obligations, where there's the professional responsibility board and the judicial conduct board, and both the chairs can speak to the very elaborate and robust and thorough rules, canons that dictate ethical obligations. So this new requirement, and I add on to Attorney O'Grady's point about something not being broke, don't fix. It's not in existence. So I don't know that anybody can say it's not broken. I would say, why fix something that is, in our view, working completely properly? We would support in terms of the proposed amendment that would exempt the state ethics panel and the House ethics panel from this consultation requirement. We would ask that the Judicial Conduct Board and the Professional Responsibility Board be added to that exemption for the reasons that, again, where there's bodies that don't have guidance, that don't have systems in place to address ethics. I again applaud the State Ethics Commission. I think that's a very useful and valuable resource. But for a system for the Judicial Conduct Board and the Professional Responsibility Board, we see it as an intrusion and an unnecessary mandate. There's already a provision in the bill that says that they will, in the existing bill, that when they make a referral, that they can include, shall signify, any likely unethical conduct described in the complaint. They can weigh in when they make the referral in terms of whatever they want to say in terms of their perspective. But otherwise, to require the Judicial Conduct Board, the Professional Responsibility Board to consult with someone that doesn't have anything to do with what the Vermont Constitution mandates, to us is just not appropriate. So that's our position. And Attorney Bent and Attorney Anderson are happy to answer any questions in terms of the processes involved with the Judicial Conduct Board, or any additional points unique to their bodies. But we fully support H1, and we ask that the Judicial Conduct Board and the Professional Responsibility Board be likewise exempt from this new consultation requirement that's being added, and it has an effective date now of September 1.
Your request has been heard. Still in introductions, associations, and immersions here. Could you please just describe what your roles are within the context of the conversation for our newer members, and as a refresher for returning ones?
Meryl, would you like to go first? And you're mute.
There we go. Can you hear me now? I'm sorry.
Whatever that button
Sorry.
was, it worked.
Okay. Yes, my name is Meryl Bent, and I'm the chair of the Vermont Judicial Conduct Board. Thank you for hearing from me today. The Judicial Conduct Board, as you know, is a creation. It's an arm of the judiciary because, as you know, under the Vermont Constitution, the Vermont Supreme Court has exclusive disciplinary authority concerning all judicial officers and attorneys at law in the state. The Vermont Supreme Court has promulgated the rules for disciplinary control of judges, which provides a comprehensive process for hearing and deciding complaints of misconduct against judicial officers. And the Supreme Court has also established the rules of judicial conduct, which are the ethical rules applicable to judicial officers. They are extremely comprehensive rules. They're carefully considered, and they are specifically tailored to the unique situations pertaining to judicial officers. And those two sets of rules govern the disciplinary control of judicial officers exclusively, and our board is responsible for overseeing that process. The JCB does not apply the state ethics code. We apply the code of judicial conduct. So we don't need to hear any input about the application of the state ethics code in regards to our oversight of judicial officers. Because the Judicial Conduct Board has exclusive expertise with regard to judicial ethics and disciplinary control, and it applies our code of conduct, the code of conduct that is promulgated by the Vermont Supreme Court, as dictated and set forth in the rules for disciplinary control of judges. The other point I guess I'd make from the board point of view is that our rules have confidentiality provisions that would mean that consultation is not a two-way street, because the JCB wouldn't share information with, discuss, or even acknowledge the existence of a non-public pending matter. So I think we would be receiving information only, and it would be about a code that we do not apply. So, I'm not sure, setting aside the constitutional issues that we see with it, what the purpose would be from the point of view of disciplinary control of judicial officers. We also, just so you know, we have a very robust process for investigating and prosecuting complaints that are within our jurisdiction. And if anyone has specific questions about that process, I'm happy to address them.
Any specific questions on that at the moment? All right.
No.
No. All right, cool.
How do you do? I'm Carolyn Anderson. I'm the chair of the Professional Responsibility Board. I've been on the Professional Responsibility Board since July 2015. I was the vice chair starting in 2018, and I have been the chair since August of 2022. I will try not to be repetitive about the exclusive jurisdiction over professional conduct by the Supreme Court of Vermont. And the Supreme Court, through that exclusive jurisdiction, created Administrative Order 9, and that order created the Professional Responsibility Program and the Professional Responsibility Board. The Professional Responsibility Board is not an active participant in the discipline of attorneys. It oversees the program. The program has screening counsel, bar counsel, and disciplinary counsel. And through AO9, Administrative Order 9, there are extensive procedures governing how complaints regarding attorney misconduct should be handled. There are very, very strict rules about confidentiality. And in fact, unless and until a complaint is gone through a probable cause hearing, and probable cause has been found so that a complaint is filed by the Professional Conduct Board, by disciplinary counsel, by disciplinary counsel, that complaint is confidential and it cannot be discussed with anyone without the consent of the attorney who has the complaint issued against him or her, or there are limited exceptions with regard to, if someone was about to commit a dangerous or criminal act or things like that. So, our jurisdiction comes from the Vermont Supreme Court. It is specified in Administrative Order 9, and we don't have any jurisdiction outside of that. So we do administer the rules of professional conduct. The rules of professional conduct are extensive, and they do govern attorney conduct even in a non-professional context. So for example, right in the preamble of the rules of professional conduct, it's very clear that if, for example, an attorney engages in fraud in a company that he sits on the board of, that's attorney misconduct governed by the professional conduct rules. And if a complaint is made, disciplinary counsel will investigate that and potentially bring charges. So the rules of professional conduct also govern government, state attorneys. So employees of the state who are attorneys, their conduct is governed under the professional conduct rules, and which are then enforced through Administrative Order 9 and disciplinary counsel and screening counsel, etc. So I think, just one other thing, if a matter is charged by disciplinary counsel, against an attorney. We then have hearing panels that will hear those hearings. Their rules of evidence apply, and if we have written decisions, and the attorney, either party, can ask for an appeal of that matter. That appeal goes to the Supreme Court. And I think what's interesting and noteworthy here is that the Supreme Court can take that matter up on its own. That's how important the Supreme Court's jurisdiction is in this. Even if no one appeals a decision from a hearing panel of the Professional Responsibility Board, the Supreme Court will and frequently does take that matter up on its own to review it.
So
Thank you.
if complaints against state's attorney, as it may be, how long does it take to navigate the process of the complaint being brought to your attention? And I mean, I understand it's a very broad question. There's a lot of like detail and specifics, but do you feel, or I guess one question at a time, what is sort of the average timeline to run the process of a complaint to discover whether or not there was an issue and how to rectify it or penalize?
Sure. And I can answer that by saying it varies considerably. So
Yeah.
the way this happens is if a complaint comes in, it first goes to screening counsel. Screening counsel reviews the complaint and has three options on what can be done with the complaint. The screening counsel can look at the complaint. He or she can conduct a limited investigation and decide that there really is no merit to the complaint. And we get a lot of those. A good example, and I'm not saying that all of these types of complaints have no merit, but we frequently get complaints against public defenders from incarcerated individuals. And generally, that is really something that the courts will handle, as opposed to being a professional conduct matter. So some of those complaints might get dismissed very, very early after that complaint is reviewed by screening counsel. If the complaint is dismissed by screening counsel, the complainant has 30 days to seek review of that. That review would actually go to me, the chair of the Professional Responsibility Board. And then the screening counsel, if the screening counsel does not dismiss the complaint, screening counsel can refer the complaint to an assistance panel. And that might be, it would never be a serious misconduct violation. It probably is something, it's unusual to have that referred. So the last thing that the screening counsel can do is if the screening counsel feels that more investigation is necessary in order to determine whether there might be a violation of the professional conduct rules, then it gets referred to disciplinary counsel. Disciplinary counsel then gets that complaint and investigates the complaint. And disciplinary counsel, there is not a time period, so it very much depends on the caseload. So disciplinary counsel will investigate the complaint and also can dismiss it if he, after further investigation, finds that there is no violation. He can seek a probable cause hearing to bring charges, and if the probable cause panel decides that there is sufficient meat there to go forward, then he can bring a complaint to the hearing panel. It is only then that complaint actually becomes public information. And then all of those proceedings, all of the filings, the complaint, everything is posted on the Professional Responsibility Board's website. So that's all a matter of public information. So just to be clear, some matters can be extremely urgent. And so we also have authority, disciplinary counsel has authority to immediately go to the Supreme Court to bypass those other procedures and ask for the suspension of an attorney's license. That might come with a significant disability, that somebody literally can no longer practice law. It could be that, to a danger to the public, an attorney who's embezzling or things like that. So there are procedures that if the threat is imminent, then action can be taken very quickly.
So do you feel that the complaints that are coming into the office and the caseload are currently moving along at an appropriate pace? Do you feel backlogged? Do you feel like you're behind, under resourced, or you're moving what you need to move in an appropriate manner?
Thank you. That's a good question. And that's something that the Professional Responsibility Board tries to oversee, how the program is being administered. We meet quarterly and we get reports from disciplinary counsel and screening counsel and bar counsel so that we can follow the progression of the cases and see how they are going. I can tell you a few years ago, we did begin to get a backlog because we had some conflicts with the then disciplinary counsel. And what we did was we worked with the state court administrator's office and we retained special disciplinary counsel, attorneys in private practice who agreed to help us administer that backlog. We also periodically review whether we are sufficiently staffed. In fact, we right now are looking at that very issue. So I do think that we are able to manage our program and oversee it so that there is not a significant backlog. Now, that's not to say that some cases don't take quite a bit longer than other cases. There have been times when a complaint has been filed against an attorney, and at the same time, there's a criminal proceeding as well. And so it usually, in that context, might make sense for disciplinary counsel to wait on the ethics complaint while the criminal proceeding is moving forward. That does not mean that that attorney would necessarily be allowed to continue practicing law. If there was a danger there, that could be taken care of. But that would be an example where that complaint and proceeding would not be finalized quickly.
No, thank you. Are there any questions from the table? No. All right, thank you, everyone. I think I'm gonna call it here, unless there's more to add from anyone. We gotta be on the floor at 3, and I need to catch up with Terry before we do the on another matter. So with that, that was a good day of work. I'll see everybody upstairs at 3 o'clock. And that is the day. I am gonna go join our friends in appropriations at 3:30 to close the loop on page 40.